Okay, good afternoon and welcome. I'm Chris Swanson. I'm the head of the forensics practice at Charles River Associates, and thanks for being with us today. There's a couple of slides that we prepared as a handout, which the ABA will email to you afterwards, and we'll pull a couple of them up here on the screen during parts of the discussion to sort of augment the discussion. So they should be, someone will be coming in, I think, and connecting this up properly. So we're going to get started without further ado. Oh, he is. Okay, well, just come on up. Perfect timing. And while we're doing that, I wanted to invite our panelists to introduce themselves. We have a really wonderful panel of people with a variety of diverse perspectives on this important topic. And Peter, why don't we start with you?
Sure. My name is Peter Chan. I'm a partner in the Chicago office of Morgan Lewis. I'm currently focusing my practice on SEC defense. And the reason is prior to joining Morgan Lewis, I spent approximately 20 years as an assistant director in the Division of Enforcement at the SEC, where I used to work with the guy over there, Dave Glockner, who was the regional director. So I used to go after bad guys, and now I help to represent people who are grossly misunderstood by the U.S. government.
Correct.
That's well put. I can't match that. My name is Steve Schwartz. I'm a vice president at Charles River Associates. I am an economist, and most of my work these days is around estimating damages in a variety of contexts. And with cyber litigation growing, plaintiffs' bar finding new and more creative ways to plead injury from cyber cases, the application of economic principles to the issues that arise in cyber cases is growing, whether it be class action or actually calculating what damages might be.
Thanks, Steve. So Steve and I work closely together. So my group, if you get hacked, helps figure out like the who, what, when, where, why, and how you were hacked. And then when the time comes to deal with the downstream litigation, then Steve and some of our other colleagues help with that. Deb.
Hi, my name's Deb Steiner. I am current Executive Vice President and General Counsel at R.R. Donnelley. I started my career after a brief stint at a law firm with, again, the guy to my right, Dave Glockner, at the U.S. Attorney's Office here in Chicago, and then off to the Inspector General's Office for the state of Illinois. In between about 7 years at the government and now coming up on 7 years at R.R. Donnelley, I worked at Latham & Watkins in their commercial litigation and white-collar defense practice group. So now at R.R. Donnelley, I'm responsible for all of those things that kind of fall into the risk function. So when we think about cyber risk, that's one of the things that would roll up to me.
Dave.
Hi, I'm Dave Glockner. I'm the Chief Compliance Officer at Citadel. We're a local hedge fund. Prior to that, I was at the SEC here in Chicago, where I work with Peter. Significant part of my role at the SEC, both locally and nationally, involved working on cyber-related issues and cyber policy, both on the exam and enforcement side. Before that, I spent about a year and a half at a cyber incident response digital forensics firm, and then the bulk of my career with the U.S. Attorney's Office in Chicago, where I got to work with them.
Good. And I wanted to also call your attention. You know, every good conference panel has giveaways. These are not business card holders. These are RFID wallets. So I know some of you travel globally, like Bev, and you can use these to help protect your business cards. Hi, John. From those bad guys who are all over the place. Hi, Carol. Okay, so what we thought we would do is use a hypothetical to guide the discussion. We're going to spend about a third of our time on the first part, and then a third in the second topic, and a third in the third, as you'll hear in a minute. But we invite you, if you have questions or comments, to chime in. There's some microphones in the room. It's a pretty small room, so we would welcome that. You have a lot of perspectives and experiences that would enrich our discussion. So let's start with the hypothetical. And the three sections that we think about in the cyber incidents area is the first part where the company is a victim, right? They've been hacked, something, they're not quite sure why or how or the nature or how long it's been going on. At some point or another, they make a disclosure, and so then they typically become a defendant because, you know, the plaintiff's bar and others will sue. And then at some point, they also become a plaintiff because, you know, there's either going to be an insurance policy or a third party or some other potential area that they can look to recover some of the costs and some of the economic harm from the breach. So that's roughly the three areas that we're going to try and stitch together today in our discussion and in our hypothetical. So let's start. Perhaps Deb and Dave, in your role as senior members of the legal team with responsibility for privacy and breach response, you hear through the grapevine that your CISOs, not at your actual companies, these are hypothetical companies, of course, your CISO seems concerned and distracted about what appears to be a sizable breach incident. It appears that your company has been targeted. Valuable customer and employee data has been accessed, and maybe even some valuable trade secrets, and maybe even some financial reporting and potential acquisition data that's not yet public information. So, so it appears, you know, as we start sort of this breach triangle that I alluded to earlier, it appears that the company's been a victim of some kind due to this hack, and it's pretty likely at some point that the company will also become a defendant and also a potential plaintiff. So let me ask Deb and Dave in particular, putting on your in-house perspectives, would you recommend thinking about these as three separate response initiatives, or would you think about it as sort of just three phases on a continuum in terms of your decision, like who to retain for law firms, who to retain for experts, or maybe you have a different answer for under different circumstances?
Yeah, I'll kick us off here. So the first thing I want to just say about R.R. Donnelley is we all have kind of a historical view of R.R. Donnelley as the company that printed our yellow pages. And so that's fair. We're, you know, a 153-year-old company. But what R.R. Donnelley is today is the company that probably has every person's in this room's information. And I don't say that to rattle you, but we print your bank statements. We print your EOBs from health insurance. We are printing a lot of things with highly sensitive information. And so these questions that we're going to dwell on today are questions that are very real for us in terms of how we are protecting your data. And so for us at R.R. Donnelley, I think because I was trained by Dave and others at the U.S. Attorney's Office, I think about it like a trial lawyer. And I say, where could this go? Try not to look at it with blinders on, as in today I heard that there's a cybersecurity breach, so I should hire Chris Swanson and those guys to figure out what the breach was. Think about it much more broadly than that. Think about it exactly how Chris is saying, which is, I'm going to be a plaintiff, I'm going to be a defendant, and I'm also a victim. And so who do I need that can represent me throughout that entire process? And part of that is including thinking about those vendor resources like Chris Swanson and his team to work with your law firm. So for us, if we were to have a breach like this, we would say, let's think of a law firm, number one, who knows a little bit about us, so we don't have to get them up to speed on kind of the longer version of the 2 minutes I just gave you about who R.R. Donnelley is today. But then number two, that entity, whether large or small, and I don't necessarily have a bias towards large or small law firms, but whichever law firm it is, has the ability to defend us when the plaintiff's lawsuits come, but also has the ability to be nimble enough to work with our insurance company on the claim, to be ready to work with regulators and prosecutors who may come along if there's a criminal case here. Someone who has that unique ability to bridge all of that is who we're going to look for from the beginning. Because I don't want to hire, one person who can operate in a singular space and then have to continue to get additional law firms up to speed if it becomes a bigger issue. And so that's how I would look at it from my perspective.
And I think that's exactly right. The one thing that I would add, just kind of thinking about how we've approached some of our issues, is that while you definitely need sort of a firm or lawyer who's a quarterback for the whole incident, there may be some places where you would want to bring on some specialized expertise. And we may have somebody who is our go-to guy on particular sorts of insurance issues who may not be associated with the initial firm that we reach out to. So I think the model that we might be most inclined to gravitate toward is sort of one sort of central focus and leadership role with other players brought in to supplement in discrete places.
Yeah, that's good.
So let's we'll move forward a little bit. The CISO has come to you and finally come clean on this situation, and there is a situation, and so you're now moving forward to do exactly, Deb, what you and Dave suggested, which is to retain a team to support you, a legal and technical team to support you. Who should engage in that retention? I mean, who should do the retention? Are you going to want the retention to go through you for privilege? Well, not you, Dave, because you're Chief Compliance Officer, right? But are you going to want it to go through someone in your legal team for privilege purposes? That's number one. And number two, who will the client be? And could there be more than one? In other words, could it be management or the board or both?
The answer is yes. I think that the critical step in this analysis is to scope the problem. And I know from working with my teams that our IT team and our security team, generally speaking, has a pretty good sense of what we're talking about when there's an issue. Was there a double stuff envelope and somebody got my EOB and Dave's EOB instead of their EOB? Or was there a much bigger issue that impacted privacy data? And so the question of who retains the law firm, to me, becomes at least partially tied to scope. In many instances, I will engage the outside law firm, and R.R. Donnelley will be the client. If we were to have a more significant issue, we would convene the board of directors, and likely the audit committee would become the engaging the client on behalf of the company in order to look into and investigate these issues a little more deeply. I think a bit more rare would be to have both the board of directors or one of its committees and the company to be clients. Unless we think that we have a very senior executive who's involved in internal misconduct, I don't think we would probably set up for both of those. But in your kind of ordinary run-of-the-mill, privacy or security issue, I'm going to engage outside counsel on behalf of the company.
And I think I'd add a couple thoughts with respect to both the timing of that and the relationship with vendors. Because if you've got an incident like what is described in Chris's hypothetical, which looks pretty bad from the surface, this is something where you really are not going to want your internal IT department doing much of the investigation. It's fine for them to gather some initial information, but their conduct ultimately will be questioned. When it comes to litigation, their impartiality will be questioned. If it turns out that they're not able to recover some of the evidence, and you're dealing with spoliation claims, you're in a much better position to deal with those if you're working with an outside independent vendor. And in general, excuse me, you want those relationships running through counsel as opposed to sort of a direct hire through the firm. And so there's a certain amount of urgency to getting counsel in place to get the vendor relationship up and running so that you can begin that really kind of important dive into the response.
Yeah, I'll second that. In any instances where we have, once I engage outside counsel, it's that counsel who will engage CRA or PwC or, a lot of the other forensic entities who will help us kind of break down the issue. That's absolutely true.
So now let's assume we're at a quarter end. We're quarter end or a year end. It's about 5 days. It's a Friday. It's about 5 days before, something has to be filed. That's, usually how these things arise. It's about 5 days before something has to be filed, and there's about 35 days worth of work that has to be done before you get a clear answer. So Peter, looking at, thinking about you and your role in advising registrants, what would you advise the company in terms of accruals or disclosures, in terms of moving ahead with the filing as planned, or the delay? What are the factors that you're thinking about as you're advising the client?
Well, I think the alpha and omega is obviously disclose accurate material facts, right? And one in your hypothetical, one of the threshold factual question has already been answered, which is this material to the company? I think very often that's what companies struggle with in terms of disclosures, is this material and so forth. In your scenario, similar to a number of cases that we heard about, this clearly materially affects the company's financial outlook and so forth. So to me, while difficult, the answer tends to be you disclose what material facts you have when you have it. I think that particularly with the SEC's guidance on cybersecurity that they've issued, and I highly recommend that you review it, they outline the different areas of disclosure filings that might be touched by a cybersecurity breach. And I think those are very important areas that you analyze. The one thing that I would be very concerned about is if the company decides that, well, this is potentially really bad news. We don't know everything yet, but we know enough to know that it is bad. Let's delay the filing. I would very seriously consider not doing that if I'm advising a company for a variety of reasons. One is because actually a company did that back in 2003. That company is called Spiegel, which used to be a retailer in Chicago. I oversaw that investigation. And that particular situation, the company had discovered they have bad news, and they thought, well, maybe we should just delay the filing of their 10K, and the company was sued for fraud. And the way to kind of think about it is imagine internal emails and discussions saying, boy, this looks really bad. We don't know everything yet, but if we disclose this right now, our stock price might go down. I will submit to you that this sounds like a great and very exciting case for a young SEC staff attorney. So I would say that delaying just because you have bad material information but not the complete story, I'm not sure I would delay that. And I would do the accrual calculation as best as you can. And by the way, it is perfectly acceptable to the SEC if you say, here's what we know that is material, but our investigation is continuing. And I think that's perfectly fine. And by the way, that is the truth.
So let's,
Can I jump in
yeah,
for a second,
please.
Chris? I think from a company perspective, the idea of delaying an announcement ever is a very dangerous thing because every negative inference will be drawn against you. It just will. Whether you have a small restatement or you have an investigation like Peter's talking about, everything negative is assumed. So if you can announce, you should announce, even if it's not fully, baked yet.
So,
Dave was going to say
Dave, sorry.
Just the companies that have gotten in trouble over announcements that have proven to be somewhat premature in terms of not knowing everything have generally been companies that projected a level of confidence in their knowledge that wasn't really there. Yeah. And so you can make an announcement, but also reflect the sort of appropriate level of uncertainty. I mean, that's not going to be satisfying to anybody, but it's the truth. It gets you sort of a step past the sort of bad place where Deb is talking about, and it at least begins to get the conversation started.
So, Peter, you've advised the company to make a disclosure, and they've done so, and they move forward according to their normal schedule. Is it a one and done? I mean, they made their disclosure. Are they home free, or are there continuing disclosure obligations?
There's continuing disclosure obligation. because one, you disclose what you know at this stage, and by the way, remember, this event is material. And so it would be very difficult to say that significant changes to the event is not also material. And so you have to make the appropriate and timely filing and disclosure. Also in the SEC's guidance on cybersecurity in particular, they caution public companies to remember the duty to correct past statements. So it's not just looking forward, but as you learn more, you also have to kind of look back. And that goes back to the idea of it is okay that you don't know everything, and you can let the world know that you're still figuring it out. But as you figure things out, the accurate information has to be updated, because there's always a danger that based on new developments, your past statement is no longer accurate.
Chris?
Yeah, I was about to call on you, Steve.
Okay.
Great minds think alike.
Where this becomes relevant when you get to the damages piece is in two ways. It's the drop in the stock price that will get the plaintiff's bar running to the courthouse. But that's not what's going to create the liability. It's how well can you defend the proposition that the disclosure that you made was complete, timely, and correct. And, you know, as an economist who comes into the 10b-5 kind of world, looking at what's been done, we are sometimes asked to evaluate, was there an economic basis for the company to have known something earlier? And oftentimes we're able to say yes or no, and sometimes we don't have that ability. But the other thing that becomes important, and this may be part of where we're headed, is when you make that disclosure and you make the corrections, those are going to be viewed in light of everything that you have said before. So if you have said, we've instituted a new state-of-the-art, high-tech cyber defense system that we believe is virtually hack-proof, even if you make a timely disclosure around the hack, the defense expert on the other side is going to go back all the way to that initial disclosure. So everything has to be done in light of what you've already said, and everything that you say has to be done in anticipation or in recognition of the fact that things can happen down the road that you don't expect, don't think is going to happen, but you're surprised. And so the range of relevant disclosures that can trigger a real damage claim that's concerning aren't just around the immediate disclosure, but around everything that you have said that's related to that disclosure at some time in the past.
So let's talk a little bit about knowledge that members of the company have that has not yet been disclosed. And what are some of the insider trading risks, and what might you do, insider trading or other sorts of ways to personally gain? What would you do, either Peter, to advise, or Deb and Dave on the inside? You know, how would you handle that risk, which of course has been in the news lately?
You don't trade on that information. So does a former Equifax employee who you could ask about that?
Two of them.
Yep, good point. But no, I mean, one of the things you need to do in the compliance or GC role is to make sure that you understand who knows, and make sure that those people are reminded of the sensitivity of the information and the potential trading risks.
Are you able to monitor that at all, or you just advise and hope?
Yeah, so I 100% agree with everything Dave said, and from my perspective, that's about process. None of our senior executives can trade in our Donnelley shares without talking to me. And so once I become aware of a situation, whether it's cyber or anything else, anybody who has material inside information, they can't get it done without going through me. And so we have that locked down. And in addition to that, I would just say this is not a police state, okay? If somebody wants to come to me and say, I'm thinking about trading and I want to make sure that I'm in the clear, and do I have material inside information, we'll have that conversation. We'll figure it out together. We'll talk to their broker. But particularly heightened level of scrutiny and heightened kind of thoughtfulness around those times when we know things are happening at the company that aren't public yet. And so it is a situation where we will stop any trades that happen during those time periods.
So Steve, let's come back to you. We've talked about materiality. I assume there are a basket of costs that might show up on the financials one day. There are also some other costs that might not. Talk a little bit about how you might be advising the company to start to track or segregate or monitor or estimate those types of costs. Well, and I assume they should be doing that now, or should they be waiting for 6 months or so?
I think the best idea and sort of the theme of think of this as holistically, think of it as a multifaceted problem. You don't know what issues are going to emerge. You don't know what lawsuits you're going to file, what insurance claims you're going to make. You don't know what claims are being made against you. But it's pretty easy to anticipate the kinds of information that's relevant. So it's important, if your system's not already set up to do that, to find a way to segregate costs. Every dollar that you're spending in trying to understand what the cyber event entailed, everything that you're doing to try and mitigate the risk, everything you're trying to do to fix the problem. And those are things that I suspect are usually thought of. The ones that are not are the things that are happening in the market. What's happening with your customers? Who's leaving? Who's staying? What's happening to the business? What complaints are you getting? What kind of blowback are you getting? Because if you're going to advance an insurance claim, you certainly want to be able to demonstrate where your business has been affected. If you're going to be talking about the adverse impact on a stock price, you want to be able to track really carefully what happens in your business after, because you don't want to be saddled with blame for lost business that has nothing to do with the cyber event. You want to be able to try and do the analysis, or at least have the information so your expert can do the analysis, so that can all be well segregated. So if it certainly wouldn't be the first thing on the list to do, but second or maybe second and a half, is to start to figure out what information do we need to segregate, to maintain and have available, so we can start to answer the questions on an ongoing basis. What effect is this having? What kinds of claims can we make, and what's the value of those claims? You want to start to do that right away.
Okay, so step 2.5, think about damages early on.
Absolutely.
Absolutely, okay. Deb, assuming that your accounting staff is typically the group that you call on to do some of the accrual calculations for what goes into the financials, how would you in your GC role get comfortable in advance that they are prepared to be able to do those calculations, either with the right data or the right expertise, or so that, because time is ticking.
Yeah. In a case like this, I think a couple things come into play here. First of all, if we look just narrowly at the fact that there's been an incident and we're trying to clean up an incident, we want our experts, we want the pros to help us do that. As Dave said earlier, in terms of thinking about who our vendors are and getting those people introduced, not only to the IT team who's doing providing them data so that they can do this analysis and access and all that type of thing, but also to have those same people to be able to work with your finance and accounting people to understand those numbers and understand the impact. I think having an entity that can work on both sides of that with you is critical. But I think the second piece of this is something that's just an everyday task that we as in-house professionals are working through, and that is getting to know the people who are working around you at corporate and understand, their skills, their abilities. We issued our earnings this morning. I have worked with these people now as a general counsel for 2 years, and I understand their process and their methodology. I have confidence in their abilities. And so all of that groundwork that you're laying down day after day after day in the mundane, when things are not explosive or having an issue, are the things that will lead you to that place of understanding if there is an incident down the road, they know how to do accruals. And I know they know how to do accruals because I've seen them do it in these 200 other circumstances that were not on fire, but were equally important to the company. And so I have confidence in their ability to drive that forward. But to end where I started, I think having those outside experts help you with that is useful in a situation where everyone's tense and there's a lot of scrutiny about it.
So, Peter, let's talk a little bit about the SEC's expectations. It seems like there have been a number that have come out around their expectations around the board. You know, the board's involvement in these sorts of matters, the board's oversight of these risks along the way, the skills that the certain board members on the appropriate committee should be able to demonstrate. Since the general counsel often has such an important role in helping to guide the board in these sorts of areas, what would you be recommending on this topic?
Yeah, I actually think it's the board and all the way down the chain and also horizontally, because if you are looking at how to best equip your entity and company, particularly with the regulator like the SEC on cybersecurity, I would say you should read the SEC's cybersecurity guidance, but also you should read the SEC's enforcement action against Yahoo. I think the new name is Eltaba, and where the SEC actually spent some time discussing what they found wrong with Yahoo, and also if you are a registered entity like a broker-dealer investment advisor, I would highly recommend that you read the case that was done under Dave called R.T. Jones, in which I actually was a defense attorney on that. But the idea to all of this, that the SEC's message has always been, is that they're not interested in strict liability gotcha. Where they have really focused is whether you have reasonable process and procedures designed to deal with cybersecurity breach. And both in the SEC's guidance, but also particularly in Yahoo, one of the interesting things about the Yahoo case was that it was clearly a material breach. And according to the SEC's press release, it stated that the breach affected what Yahoo internally called their crown jewels, which is substantial amount of personal subscriber information and data. And the SEC emphasized that between the time of the discovery by Yahoo of the breach and the time of the actual disclosure, it was a 2-year process, 2 years, until 2016. And the SEC really emphasized the amount of time it took. But then they went deeper into that in trying to use this almost like a case study in discussing what the SEC expects. They talk about the fact that it was the left-hand, right-hand situation, which is that even as the IT staff was assessing what's going on, the IT staff from a process procedure standpoint was not expected or was not actually informing the disclosure committee of the company. They then went one step deeper and basically said that the Yahoo internally was not notifying the right senior managers, but also not notifying the outside auditor of what should have been viewed as a material event. And then the SEC said, and they failed to disclose the breach to Yahoo's outside counsel, who could have assisted Yahoo with making an advice on disclosure. And so if you kind of step back, and by the way, ominously, the SEC in the press release said the investigation is continuing. But if you have to step back, the message from the SEC is, at a minimum, they expect that you have a process and procedure ahead of the breach, so that from an organizational standpoint, and this is particularly important when you're in a part of a large organization, that you have a process procedure so that people are all communicating with each other. To go back to the SEC and say, we failed to do that because so-and-so forgot to, didn't know he's supposed or she's supposed to tell so-and-so, is not viewed as an excuse, but if anything, it's a view of at least negligent behavior. Along that line, I think the SEC, and it goes back to your board question, is if you think about this overall structure that has to be designed, I do think a lot starts with management and also at the board level, because the SEC has clearly highlighted this as an important risk, potential risk to the company. And I think it would be difficult to say that the board never thought about it, or the board was not involved in the design of the process and procedures and so forth. So process, procedure, no silos. You cannot have the IT department making decisions to whether a breach is important or not. It has to be in consultation with the right people, including the disclosure committee. Hopefully there is one. And also with oversight by the board. One last thing I want to add to that, because there's no SEC case on this yet, but if I am to put on my former SEC hat, and if I'm trying to make Dave happy in his former role as my boss, one of the things I will be thinking about, depending on the nature of the breach, particularly for a public company, is if the nature of the breach or any potential breach is such that it can affect your internal corporate data, such as your customer base and so forth, to what extent is that also a accounting internal control issue and problem? So it seems to me that, when we discuss this problem dealing with the SEC, you have to kind of think about how the SEC would look at what you did before the breach, and of course, as we discussed on disclosure and inside trading, what happened afterward.
Yeah, we had a client where their data was corrupted, but they were still able to get their external auditors to sign off through alternate procedures. Through alternate procedures, they were able to confirm the balances, so it didn't get to the SEC. But that was a pretty scary time for them while we were working through all that for a couple of months. Deb, what would you, in terms of helping to make sure the board is able to demonstrate in retrospect that they've demonstrated appropriate oversight and guidance on this stuff. What should this be part of the audit committee? It should be a separate committee. What sorts of things should be presented by the company to the board on a periodic basis? What have you either seen or heard, or what are your thoughts?
Yeah, from a board perspective, this is something the cyber and security risks had reported into the audit committee, and I think that was the case for many companies, although I obviously can't speak for all of them. When the revised SEC guidance came out talking more generally about board of director knowledge and involvement in cybersecurity risk, we moved that to the board of directors full meeting, so that everyone on the board is now engaged and active around cybersecurity and how we're managing it as a company. And so if you think about the way a lot of boards operate is with standing agendas, and these are the items that need to come up to the board level on an annual basis for conversation, many of them multiple times on an annual basis. We shifted this one from a committee level to a board level so that the whole board has some visibility into this. And whether or not that becomes best practices for the board, I don't know. But for our company, we felt like that was the right thing to do, was to have our Chief Information Security Officer and his team come in and have significant time with our board on an annual basis.
And who does your CISO report to, Deb?
The CEO.
How many of you have CISOs who report to the CIO? How about CISOs who report to the GC? Well, you have one of each. CISO. How many of you don't have a CISO? Maybe that's a better question. Well, that looks good, actually. So we talked a little bit about engaging with the regulators and with law enforcement. And of course, in addition to the SEC, which we've talked about mostly today, there's also the Federal Trade Commission, which has been working to establish relevance in this area, and the numerous state AGs, the FBI, the U.S. Attorney's Office. So we have a combination of regulators and law enforcement. What should the strategy be in terms of how to engage with them, when to engage with them, and what to assume about the level of knowledge sharing that may or may not occur between them?
Maybe
Dave?
I'll start with that. First in terms of knowledge sharing, because I think this is something that may not be sort of generally understood, and there's really been some evolution in the law enforcement and regulatory space over the last probably 5 to 10 years. So at this point, very little information is shared between law enforcement and regulators in the cybersecurity space with respect to kind of details of a particular incident. And the reason is that both law enforcement and the regulatory community think that it's very important that companies that are victims of significant incidents be comfortable reaching out to law enforcement for assistance at an early point before they have sort of fully thought through, do I want to tell the regulator or not? And the When I was at the SEC, we worked very closely with the FBI on a number of incidents, but those were typically things we referred to the FBI. There were times when the FBI would refer things to the SEC, but only with the permission and sort of at the direction of the victim. When I was with DOJ and working on cyber incidents there were incidents that would come in and the companies would ask us, they'd say, we haven't made a decision yet about disclosing to the regulator. And we would like just to work with law enforcement on this. And both sides respect that. I think that if you have an incident, you want to be explicit about that with whoever you're dealing with. But you don't need to assume that disclosure to law enforcement equals disclosure to the regulator. And there are a number of reasons that depending on the significance of the issue, it may be beneficial to be able to reach out to law enforcement earlier rather than later. I mean, there are things that law enforcement can do that not the best civil
We can't legally
responders.
do is what Dave's
Yes.
trying to say.
There are search warrants, potential undercover opportunities, contacts with international authorities, all sorts of tools that are in the law enforcement toolkit that, depending on the circumstances, can be very useful for the company in kind of containing the incident, sometimes getting whatever was taken back, sometimes making sure that whoever did it is held accountable. The counter risk, and I think Deb and the others in the panel can speak to this, but you do lose a certain amount of control once you bring in a third party.
So how about the privilege issue, Peter? Are there privilege considerations in terms of engaging and disclosing to regulators and law enforcement, or is everything, or what's your thought?
Well, a couple of things. One is in terms of privilege, there are ways to provide information without necessarily, breaching privilege. But every time you make a disclosure to frankly, not just the government, but to anyone, you obviously have to go through that cost-benefit analysis. But one thing I would say, just as a follow-up to this discussion on law enforcement regulators is that, I think holistically, you start off with the idea, and it goes back to Chris, your scenario, which is that the entity can be both a victim and also a defendant. And as a defendant, you could also be a defendant to regulatory actions. And so you kind of have to step back and say that, when you look at the government as a whole, you kind of have to look at it not as a single entity, but as different entities. I absolutely agree that when you disclose to law enforcement, the primary reason is, one, because you're a good corporate citizen, but also, two, is law enforcement is here to try and catch the perpetrators or to stop the perpetrators. So that is a very real and important consideration as to how fast you want to reach out to law enforcement. And I think Dave is right, the international capability and coordination is also much greater. So you can't always assume that they won't catch the bad guy. They could. But related to that is, before you talk about when and whether you should disclose to regulators, you need to kind of step back before there's an incident, when things are calm, and ask yourself, who are the potential relevant regulators that would care, so that you're not so rushing in that decision. I think it is problematic sometimes from a overall diplomacy standpoint if you bother to inform one regulator and decide not to talk to another regulator. Not that there's a requirement to do so, but I think you can inadvertently create issues in terms of relationship if you do that. So think about who are your regulators, and obviously that depends on who you are. If you are a financial institution, that changes things, versus if you're a public company, or if you're in the healthcare industry. And obviously the FTC has been getting more involved in terms of defining cybersecurity practices as to whether that create unfair effect on consumers. So think about that list. I think the more difficult one, in terms of whom you should consider as potential people to inform, would be at the state level. In terms of, obviously there are state law governing notice of breach requirement to begin with, so obviously you have to follow that. But separate from your statutorily required disclosure, I think one of the question is who are the AGs, depending on your business and so forth, that you think it might make sense to give that extra effort of calling them if you decide that's the right thing. From the sense of assessing whether you should make the disclosure, assuming that, again, that you think this is a material breach and so forth, I think the thing to think about is that regulators are going to be interested in look at, from a time standpoint, before and after. The before is going to be, for instance, with the SEC, with public companies or registered entity, is did you have adequate procedures? So that's one thing they are in process to deal with potential breach. So they're going to look at that, and so you might want to actually disclose to them so that you can start that dialogue as to what happened before, but obviously after, and that goes back to disclosure if you're a public company, but also in terms of insider trading and so forth. I think the idea is that if it is generally up to me by default, I would tend to err on the side of disclosing to the right regulators as opposed to waiting for them to find out. And nowadays, the likelihood of regulators finding out that there's been a material breach is frankly very, is there. It could be because of the required notice requirement that you have to make anyway to affected parties, be it your customers or otherwise, but also because there are actually this whole thing called the whistleblower statutory provision that encourage whistleblowers to go to the SEC and others. And so you actually cannot assume that if you keep the information to yourself, that it won't get out anyway. So if with all things being equal, I would probably err on the side advising disclosure to the right regulators, and obviously the challenge often is who's the right regulator. But again, it's a case-by-case situation.
I think we have our first question, ma'am.
Yes, you say case by case, yet many, if not most, shareholders and members of the general public expect crimes to be reported. In fact, it's against public policy, many of us believe, when you have crimes that you do not report. So that's a concern that's held by many shareholders and many members of the general public. You mentioned statutory requirements to report just now, and I'm not sure that there are statutory requirements to report a crime, and maybe you could speak to that, but not reporting crimes, whether, even those crimes taking place regarding companies and cybersecurity, and not reporting it to law enforcement is a real negative about the company to many, many people, and I'd like you to keep that in mind.
Oh, no, I absolutely agree, because I think in our scenario, we already assume that the entity has already reported to law enforcement. So I think the question is, right. So I think the question then is whether to, make the phone call to other regulators and which regulator. In terms of the requirement, as many of you know, both in terms of, existing regulations and so forth, and also among different states, if there is a breach that affects consumers and customers, you may have to notify those consumers anyway. And I think that's the requirement I'm talking about. But you're right. Often the question is what's the right thing to do. But I think where is more nuanced is where once you have already disclosed to law enforcement, and once you have fulfilled all your notice requirements, who are the other regulators you may make the phone call to? And I think that is a decision. And like I said, I do err on the side of calling the right people.
Well, that's a great point. Let's go back, though, and say maybe to Deb and to Dave, what if somebody in the room is in a legal capacity and there's been a breach and the business head doesn't want to make the disclosure. You know, it's embarrassing, it's big, it's material, it could disrupt business, it's a low margin business. I don't know. I mean, then people have different reasons. How might you advise people to handle that situation?
I think the question of disclosure for a company is a very serious one, and it's one of the hardest ones we face. And I would say that question is difficult, not necessarily from a law enforcement perspective, as in we were a victim of a cybercrime and should we call the police, but more from some of the other topics of the day from the past days now of like FCPA. And if there's an issue, do we report it? Do we have, an analysis of when we report that and when we don't? And I think, I appreciate your question, ma'am, because I think that the shareholder voice on all of this is very important. So I appreciate you for speaking up. And I also think that when you have the reticent member of the team who doesn't want to disclose, that's where those rigorous conversations come in. Okay, that's where you're all in a room together with outside counsel, usually talking you through the analysis of what do you need to decide in order to decide to disclose this. Having said that, I agree with Peter that there are laws that don't make that a decision. For example, if your healthcare information is exposed to anyone, to one other person, the Attorney General's rules across this country require that you get a letter from the person who inadvertently disclosed that to someone else. And so there are some very specific rules around, protection of health information and protection of things like Social Security numbers that require disclosure. So to answer your question, Chris, it kind of takes it out of the hand of the person who's saying it's embarrassing, we had a mistake. I agree, it's embarrassing, and now we have to, kind of suck it up, Buttercup, and do what the law requires us to do. But for those that are not required, I think that's where the hard decisions come for a company. And you have to consider all stakeholders, from the regulators to the shareholders to company goodwill, the board of directors, the executive team. All of that comes into play in those decisions.
And the whistleblower risk.
Of course,
Right.
Whistleblower is high up on that regulator risk.
I think with respect to the SEC disclosure question as to, if you're a public company, the SEC has been really explicit that they are not going to second guess reasonable decisions about disclosure by public companies. They understand that it's a challenging area. And in some ways you can read the Yahoo case as sort of an affirmation of that point. Yahoo is not one of 5 or 10 cases out there charging public companies for failing to disclose material cyber security events. It's a unicorn, at least at this point. And when you look at the facts of that case, and Peter did a great job of summarizing them, if the SEC was not going to charge that case as a disclosure failure, there's really not a case they can charge. So I think that you shouldn't look at Yahoo as a public company and think, oh my God, they're going to be crazy about making sure that we disclose everything, and we need to go running to the SEC every time we have an incident. I don't think that's the right way to read that case. I think the way to read it is that we need to have the serious internal discussion that Deb talked about what are our obligations, what are the competing interests at stake here, and we're going to make a good faith, straight decision about where that comes out. And sometimes it will come out in favor of disclosure, and sometimes it won't.
Sir, I think you had a question.
Yeah, my question was, Deb made it very clear, you have to task people to do different things. Who calls the FBI? Who calls the state? Is it your outside firm, or you as the general counsel, are you on that call?
So who calls the regulator? Who calls law enforcement? I think is the question, right?
Yes.
Yeah.
Yeah. I would err on the side of outside counsel in probably 90% of those instances. To the extent that you have an outside advisor engaged, it's best for that person to handle it. If the facts are going to go deep, if it's not just a quick call, hey, we want to let you know this is unfolding and we'll be updating you and there's a disclosure coming, that kind of call, fine. But if it's more of a factual recitation, then I would want a company official to be part of that conversation at that point.
I think also a lot of the law firm partners with expertise in that area are known and have credibility. Deb has credibility, but she has an unusual background that very few people in the room have. So I think that's been very helpful for a number of our clients is to have that interface with somebody who's known and trusted to the regulator. Steve, you were going to add.
Just a thought on disclosure, looking at it from the perspective of the damages expert. The states are a huge problem because you have 50 sets of rules with 50 sets of provisions regarding damages, many of them providing for statutory damages based on the amount of information disclosed and the delay in reporting it. And they're two separate buckets. And you can't really get away from the first. I mean, if there was a breach and a certain amount of information was disclosed, oftentimes state legislatures have already said this is what we're going to assess, or this is what's available through the courts. But there are some states, and I wish I had brought the list with me, which set regulations, and they also charge you for the length of time it takes you to report beyond some reasonable period. They give you some period to assess. In the extreme, if you've got a Yahoo situation, on top of everything that the SEC can do, on top of everything that the federal courts can do, you've got 50 states that are going to look at it. So unnecessary delay or delay in getting all of the information out can also trigger damages. So really being thoughtful about what your state obligations are can make a big difference in mitigating the bottom line end damage that you're going to have to pay out.
Steve, haven't cities or counties or smaller regulatory units latched onto this potential revenue opportunity as well, or is it just states?
The only thing I've seen on that is a city in California, and I don't recall which one, had a city statute barring the unauthorized disclosure of personal information. And I don't know whether that ever passed, and I don't know whether it would pass muster. But that's the only city that I've seen try and do it. But on a quick review, I think every state has its own rules. So it's a mosaic, and understanding all the elements of that mosaic, every piece of it, can make a big difference in how well you're mitigating the financial exposure.
In terms of understanding the mosaic, I'd encourage you to keep an eye on essentially evolving legal technology in this space. So there are more and more law firms and other vendors out there that are starting to build sort of automated tools that help you work through complicated issues. And we recently were approached by one of our law firm vendors that has built a tool for use in breach incidents where clients, and they're not charging us for this. I don't think they're charging their clients for it generally, but you can plug in basic facts about the breach, including states, and it will sort of walk you through state disclosure obligations, provide links to relevant state statutes, provide you with timelines. So a lot of these kinds of process issues that make breach response challenging are susceptible at some level to technological assistance. And yeah, I think the kinds of tools that are out there now are relatively primitive, but I think it's something that is fairly quickly going to become much more available. And as you and your clients start working through these issues, I think you're going to have a lot more assistance in wading through this maze pretty quickly.
Okay, so we've spent the most time so far in the victim phase. We're now going to transition, because I mean we could continue on this, but we want to cover the defendant phase and the plaintiff phase. So we're going to make the transition. Let's assume that the investigation has been completed and some kind of carefully worded notification has been sent out to customers and employees, perhaps offering free credit monitoring, perhaps an RFID wallet, I don't know. and warm assurances that no actual evidence of data misuse has been observed to date. So Deb or Dave, is it fair to expect, probably Deb more than Dave since you're not publicly traded, but that within minutes of sending out this notification that it's going to come back as Exhibit A to some kind of plaintiff's class action complaint, perhaps representing a class of shareholders or customers or employees or investors or maybe some sort of creative derivative action? Or all of the above, yes.
The answer is yes.
I would give it at least a week.
Yeah, exactly. It may not be the next day, but it's likely to come, yes.
So Peter, so that goes back though to the earlier point I think you guys were making that you really have to think about this whole continuum because what you write in this phase has a potential to impact the next two phases, right?
Absolutely. It'll be used all the way down the road.
All the way down the road, yeah. So Peter, it seems, I'm not a lawyer, but it seems to me that the plaintiff's bar takes the position that if the breach happened, it was foreseeable. And if it was foreseeable, it was preventable. And it was simply a matter of whether, any number of things. Maybe you were slow to report, maybe you were underinsured, maybe you were non-compliant, your client was non-compliant with legal and regulatory obligations, maybe they negligently retained data for too long, maybe they negligently failed to encrypt data. These are the sorts of claims I've been reading. Which of these evolving theories of liability, from your perspective, seem to be getting the most traction and should people be paying particular attention to?
I think particularly in the this whole reasonable behavior negligent standpoint, I would think we're the one that has the most traction, and I think it is for both private litigation but also for regulators, is what I would call a failure to respond to red flag standpoint, and the reason is because I do think that in front of fact finders and so forth, the idea that if there's a breach, someone must have done something wrong. I think that is quickly changing as a matter of people's understanding of events. That you can be whoever you are, a breach can happen. And I think that the more viable liability theory has been when you have a red flag that there's a deficiency and you fail to address it. That to me is if I'm in the plaintiff, if I'm a regulator, I will pay attention to. And what we talk about when we talk about red flag, not the red flag that the breach is going on right now, but red flag of deficiencies. So for instance, if you are part of an entity, be it private or public, and you have a memo from your IT department saying that, we haven't spent sufficient resources on X and Y to deal with a potential cyber breach, that's a problem. If you have situations where you notice that many of your employees have not completed the tests or training on cyber security prevention, that's a great piece of evidence of a red flag that your system is not up to snuff. So I do think that red flag, failure to respond to red flag is probably, and you can see it in different ways, is probably the potential most fruitful liability. The flip side of that, of course, is that if you can document when there's a red flag that your company adequately responded to that red flag, I think that mitigate the liability risk.
And Steve, similarly, what are some of the damages theories that you've seen the plaintiff's bar testing out, and then of course the successful ones it seems like the regulators start to then borrow as well?
The range of damages theories is limited only by the creativity of the plaintiff's bar, which is to say it's really unlimited. The claims are tending to focus on a couple of theories. The one that I think has the most potential viability is kind of a negligence theory, consistent with what Peter just said, and there has been some writing suggesting that the viable theories can follow the model of the products liability bar. in developing damages theories, because oftentimes product liability claims are built around people who may have suffered direct injury, a small number, but for everybody else there is a risk of injury. And models are built off of that. And it may be a way to deal with the problem that the plaintiff's bar faces all the time of having huge classes of potentially injured parties, none of whom have suffered any real injury yet. And they run into the challenge of how do we have standing if we can't show actual injury? And is it enough to meet that hurdle to say, well, the mere likelihood of injury is sufficient? And the record hasn't been real good, so I think the negligence theories may provide a damages framework that can overcome that hurdle. It's real easy to claim a damage when somebody can identify an explicit cost. They couldn't get a mortgage because their credit report was sullied because somebody stole their identity. But on a class basis, those are impossible to adjudicate. In fact, making those kinds of arguments defeats your class cert arguments, so the plaintiff's bar tends to stay away from those. So I think since the plaintiffs haven't had a whole lot of success asserting likelihood of injury in the future, at least at the federal level, these negligence theories will take more hold. What is interesting is that the states have been more willing to entertain those enhanced risk of injury and therefore we've been damaged theories in certifying classes and letting those cases go through. How those are going to proceed is unclear, and in particular, how they will proceed in light of some of the recent decisions on how broad the scope of a class can be when you're litigating in state court is going to be really interesting. And one of the challenges that plaintiffs are running into, which they will find a way to overcome, I'm confident, is that mosaic of state law.
Yeah.
It makes it really difficult to sustain state classes. And there was an article several weeks back in Law 360 where the writer basically said what the plaintiff's bar ought to be doing now is carefully investigating state law to try and find what's common and what isn't, because you may not be able to do a nationwide class, but you may be able to have subclasses of states with broadly similar provisions.
So, Peter, let's take a step back to when you were at the SEC, and David, when you were at the SEC. So, if thinking about the people at the SEC now, and we're assuming that this is a material breach, things have been disclosed. Peter's talked about the red flags. What are some of the inquiries that you think might be forthcoming from the SEC, and what might they be coming in terms of days, weeks, months? And what are some of the penalties that a company might be thinking about trying to avert?
Well, as you know, the SEC, in terms of its oversight, deals with both public companies, but also non-public but registered entities such as investment advisors, broker-dealer firms, and mutual funds, and so forth. So to me, from an investigation standpoint, those two buckets. I think with regard to public companies, I think Dave is absolutely right. The signal that the staff and the commission and the chair, Clayton, have been sending is that they're not trying to do a gotcha, and that they understand that breaches happen. And that, if you look at the Yahoo case, holding on to material information for a company like Yahoo for 2 years and by the way, even as they're negotiating an acquisition by Verizon and so forth, I think you can understand why the SEC did something like that. What we have not seen with public companies, what I call the aggressive push the envelope kind of cases, where reasonable minds can disagree. And I would think that on a public company side, and obviously you have cases like Equifax, where the chief information officer alleged to have done insider trading. Imagine that. Aside from these type of cases, I don't know that it would make sense for this enforcement division to spend a lot of resources, going after things where reasonable minds can disagree. Where I actually think where I would sort of separate a little bit is that I think there's greater expectation, particularly with registered entities, financial institutions like broker-dealers, investment advisor firms, and so forth, on protecting information of customers and clients. And in the RT Jones case, the RT Jones actually detected the breach, and they notified the potential clients and did all the things. The ultimate settled case by RT Jones was that they actually do not have an actual written procedure in terms of protecting customer information under Regulation SP. And I think with registered entities, such as broker-dealers and so forth, I think the SEC will continue from an examination standpoint, from an enforcement standpoint, investigation standpoint, be very focused on whether these registered entities are fulfilling their regulatory responsibility in protecting customer and client information. So I do see that as being two separate buckets.
There are, I think, though, that to be fair, Yahoo is a relatively recent case, and the new guidelines that came out from the SEC were earlier this year. So, I mean, I wouldn't want people to leave thinking that this isn't a clear and present ongoing regulatory danger, perhaps. What about like the whistleblowers? The SEC and others have all these whistleblower hotlines and whistleblower payouts. Do we think that maybe there are some whistleblower claims relating to undisclosed breaches or non-timely breach responses that may be percolating there?
Yeah, just to step back over on whistleblower, one of the things that I'm sure many of you are aware of is the recent Supreme Court decision on whistleblower retaliation claims, and the Supreme Court's interpretation of Dodd-Frank whistleblower is that you are not a whistleblower for the purpose of Dodd-Frank unless you have reported to the SEC. Okay, so for instance, if in a follow-up federal district court decision dealing with UBS, the alleged whistleblower have argued that he or she had provided information to FINRA, which is a self-regulatory organization. And the federal district court in New Jersey dismissed that case under Dodd-Frank by saying, yeah, but you have not reported to the SEC. Okay, so what does that mean? On one hand, if I'm an employment lawyer doing a defense action, I'll be very much delighted by this case. The flip side of it is that if I am a plaintiff's attorney or whistleblower attorney advising a potential whistleblower, I'll be saying, hey, you know what, it would be safer if you report to the SEC earlier rather than later. And so one of the potential effect of the Supreme Court decision is that you'll have great incentive for people to make a whistleblower report to the SEC. It doesn't take much to imagine that if I am in a company for a variety of motivations, if I'm someone that would consider being a whistleblower, that if I'm part of the IT team, if I'm one of the people that are aware of the cyber breach and I feel like things have not been done correctly previously, the chance of a whistleblower report I think is not that unlikely. And obviously then all the issues we have with whistleblowers, be it retaliation, be it that your severance agreement cannot be, or other types of agreement cannot be, have a chilling effect toward whistleblower, that all comes into the cybersecurity space also.
And any payment for the SEC cannot be assigned over to the company, right?
Correct.
Yeah. So let's switch. We're running low on time. Let's talk a little bit about, now we're moving into the plaintiff phase in our discussion. And so I put up one of these are in the handouts that you'll get emailed later. I've sort of had these playing in the background during our discussion, but we'll send all these to you later. Steve, why don't we talk a little bit about, if a company is thinking about whether or not to try and recover costs and damages from a third party or under an insurance policy, obviously part of that calculus is how large the damages are. So what are sort of the, I mean, there's some of them are easy to see, and a company might think about themselves and might even be able to quantify themselves. Some of them I think are not going to run through the financials, are not going to run through the GL, but in some cases can be much larger from an economic perspective. So can you talk about this a little bit as, as a company is thinking about trying to size up the damages, maybe the two streams that they might go down?
Sure. I think we're looking on the right side under advanced damages. I think a good way to think about this is to construct in your mind a but-for world. What would have happened if we didn't have the breach? You've already made the disclosures, you've complied with all of those regulations, but what would have happened if? And if you think about it, then a lot of those buckets that are identified there really can get squished into much broader buckets with a lot more pieces. I mean, increased customer turnover. Well, that's really an element of lost profits. Trying to think what else is there. Reputational harm. That reputational harm matters because it affects how many customers are willing to do business with you and under what terms and conditions. So that becomes a lost profits kind of element. Incremental costs that were incurred. We are now viewed differently by our lenders. We're now viewed differently by the bond market. We're now viewed differently by the stock market. So our cost of equity, our cost of debt has risen in a demonstrable way. Now you've got causality issues there, but there's a higher cost of capital, incremental cost kind of element that you would factor in. So I think while there are all these categories, it shouldn't be overwhelming. If you really think about them, you can kind of squish them down into 2 or 3 at the most, where you really need to focus. And circling back to something that I said earlier about tracking what's happening. If you want to prove up a lost damages case, you really need to know what's happening in your business on a granular level. It doesn't mean that you, the company, will be analyzing the data that way, but you're going to need to give it to an expert who's going to be able to say what's really happening here, and then try and build the causal link back to the breach and the effect that had on customer relationships. And so what we talked about early on about tracking that information and gathering it becomes critical when you want to start to assess, do we have damages claims? Are they legally viable? Are they economically viable? Meaning, are they large enough to be worth pursuing? Assembling that data on an ongoing basis will allow somebody to do that analysis and say, we're talking about 7 figures, 8 figures, 9 figures, and help you make a reasoned business judgment as to whether this is something that's worth pursuing.
And if I can just kind of jump in, very quickly, one thing I noticed with a lot of breaches, including some cases I was involved in, the breach actually originate from outside vendor issues. And I know, and I'm also curious in terms of what Dave and Dave think is that, obviously there's been a lot of activities dealing with due diligence of outside vendors on cybersecurity safety and all that stuff. So obviously one of the question on whether you can be a plaintiff to recovery costs is particularly in situations where the outside vendor is the cause, and I don't know whether that could be breach of contract claim also, because and maybe Deb and Dave know better than I do. I know a lot of outside vendor agreement now have clauses dealing with cybersecurity safety and so forth. So I don't know, maybe that's part of the discussion.
Well, let's hold that, because I'm going to give, in just a second, thank you for staying with us for this hour and a half. I'm going to give every panelist a chance to give one closing piece of advice. But I have one more question for Peter. So Steve, my partner Steve here, has come up wearing his plaintiff's hat. He's come up with the mother of all damages calculations. There's just a lot of zeros after that baby. But at the same time, you're disclosure counsel, or maybe one of your partners is, and in your financials, you've disclosed that this has been a breach. It's been deeply distressing, but it's not been material. You've just, in an abundance of caution, it's not been material. Now, maybe that was a month ago, and maybe Steve has more information today than you did a month ago, but is there any risk in terms of reconciling what goes into the public filings versus what goes into the expert damages report?
Yeah, and this is both as a defense attorney, but also as a former SEC guy, I would say be very careful about going down that road in terms of thinking. I would, again, the alpha and omega has to be accurate disclosure of material facts. And I think it's a very dangerous dance when you start saying I'm putting something in, but by the way, it's really not material, because that in itself could be a lie. So I would say that you almost, it is what it is. You disclose what is expected and what is required and what is the right thing to do. And then you hire guys like you guys to try and figure out what the potential damage is, to sort of do a sort of, reverse decision making on disclosure and say, if we say it this way, it might affect our damage. Be very careful about doing that, because the flip side of that is that starts creating very decent evidence on fraudulent intent.
Okay, so now we're going to have one final round of from our esteemed panelists. Deb, why don't I start with you? Any tips, final words of wisdom, recommendations?
Yeah, I think this is probably the number one area right now that we see in the law where things are evolving quickly, and it's something that we need to keep aware of, whether we're sitting inside of a company, outside of a company, at a law firm, we're a regulator ourselves, or we're advising companies in any capacity. We have to stay in front of this, and we have to stay on top of it. I think you need to find the right advisors, because you can't know everything, and have those people in place before an incident happens so that you can be ready. One of the questions we didn't get to today, but I'll throw it in here just because it's interesting, is ransom. Mm-hmm. What happens when someone holds up your company or your law firm or wherever you have data for ransom? Like, if you had told me 15 years ago that we would have been talking about, well, we need a ransom policy, I would have looked at you like you were crazy. But now we do. Okay, you got to have a ransom policy. So that's kind of anecdotal to understanding that this is a rapidly changing area that we need to stay on the front edge of, and that's my advice for the day.
And could a ransom payment be a violation of the FCPA? Come back next year, we'll continue the conversation. Dave.
What Deb said is exactly right. I think the way to make sure that you're sort of thinking about these things and keeping it a priority is to have a thoughtful, rational governance process with respect to cybersecurity risk. The area that I have seen companies fail over and over from all the different seats that I've sat in has been in not having a process within the company's governance structure for where this risk sits. Who owns it? How do you communicate about it? How does the reporting flow? And you have to get that right before you really can start putting these other pieces into place, at least in any way that's going to stick.
Mm-hmm. Peter, let's go to you.
Yeah, I think it goes back to what everyone's saying, but I think one of the biggest lesson is that before there's a breach, you got to make sure that the people know to talk to each other when there is a breach. And where I've seen over and over again problems similar to what Dave mentioned is that someone knows something here, and the right people are not aware of the situation or the developing information. So I think that not having silos and having communication lines is important. And then the last thing I would say is when there's a red flag, address it and then document how you address it.
Thanks, Peter. Steve?
To echo one point that we made earlier, start thinking about the damages early. I know when you're in the middle of a swamp and you're surrounded by alligators or whatever that college dorm poster says, it's hard to think about the damages. But when you get to that litigation stage and you're dealing with the claim, and now you're trying to figure out 2 years worth of stuff, and where is it, and how do I find it, and is this valid, and what's the right information? We've talked a lot about process. It's nice to have a process to think about who's the owner of that information. What information might I need? Where do I get it? How can I segregate it? That's point one. And point two, just to something that I thought of as Peter was talking a moment ago, materiality has a very specific meaning to all of you as lawyers, but materiality does not equal large damages. So the fact that you have made a material, that there's a material fact, you've made a disclosure, and it may or may not be actionable, doesn't mean that you're looking at a big damages claim. Ties back to my first point, engage your damages experts early so they can keep you apprised on an ongoing basis what your exposure might look like.
So I'm going to end with some happier thoughts, with a happier suggestion. So you've been the victim, costly, right? Distracting, painful, terrible. Then you've been the defendant, so it's like you're getting piled on. Again, costly, embarrassing, painful, executives doing depositions, terrible things, right? On the plaintiff's side, you may have a management team that doesn't have the budget to invest more money in recovery of some of these damages. And I think what's going to be interesting to see in the coming years to keep your eye on the litigation finance firms, who I think are getting increasingly comfortable at sharing the risk. And it comes off your income statement. So then there's they're bearing the cost. Obviously, they're going to share in a portion of the recovery, but the actual cost of the litigation is not something that's going to go through SG&A. So for my public company clients, I've been hearing increasing questions and interest in exploring that. And that might be another topic we'll get to next year if the ABA gives us enough time to cover these important issues. Thank you all for coming today, and thank you to our great panel.